The Court of Appeals is now in session.
Good morning and welcome to the Court of Appeals today. We are here to hear oral arguments in the matter of J.J.W. Counsel, if you would please enter your appearances for the record.
Alexander Marshall for the appellant father.
And John Hancock, I represent the appellees, the maternal grandparents.
Thank you both. I know, Ms. Marichal, you've been here, but Mr. Hancock, I don't know that I've seen you before. So if this is your first time appearing in the Court of Appeals, welcome. And do you have any questions about how this process goes?
I do not. I think I got it.
You got it.
Yeah.
It's really not that difficult, but I will just note, just for everybody, if when you are not making your argument, if you would please mute your microphone and turn off your camera, that will allow us to focus on the attorney who is making arguments at that moment. And if we don't have any other questions, Ms. Marichal, please begin.
Thank you. The district court here terminated father's rights without conducting a proper best interest analysis. It's important to note at the outset that this is not a DCFS case, and this distinguishes it from other cases this court has heard recently. Had this been a DCFS case and father had completed the steps that he completed here as successfully as he did, he probably would have gotten custody of his child back without a petition ever being filed. Also concerning here, there is no guardian ad litem to represent the interests of the child. This is a private party, maternal grandparents, seeking to terminate father's rights. The district court had essentially no contact with these parties prior to the one-day WebEx trial and where it ruled from the bench. And father was not even able to present all of his witnesses due to an objection on Rule 26 from Grandparents' Council. With that in mind, the district court's cursory best interest analysis here is all but a reversion to the almost automatically line of cases that this court disavowed in BTB, where once grounds for termination is found, termination almost always follows. But that is not the law. The law requires that a court undertaking the best interest analysis identify and consider the alternatives to termination, conduct a holistic analysis that considers the particular and present-day circumstances surrounding a child, start from that default position that preserving the family is in the best interest of the child, and terminate only where no other option will serve those interests. The court did none of that here. This case is very factually similar to BTB in the sense that it's a private case and we're dealing with a private petition to terminate. But there are even less findings here to support the Strictly analysis than there were in BTB. First, we have the legal error of not considering any of the alternatives. The alternative here, the obvious one, was custody and guardianship with the grandparents. That was the current arrangement. It was the status quo. So it was fairly obvious as a possible solution to the problems that the court had. Yes.
Can you talk, while you're on that subject, can you talk for a minute about the preservation issue that's been raised by Mr. Hancock's side? As you point out, it was the status quo. It was what was in place at the time. The criticism being leveled here is that there wasn't a specific request from your side that the court consider that alternative in connection with its best interest analysis. Can you respond to that?
Absolutely. So our first position is that it is preserved, not only because it was the status quo, but because there were several arguments made in closing, record 690, 687 in closing arguments, and also in father's testimony about not removing the children right away, keeping them in right in their current circumstance, going through therapy, things like that. So it was presented that the intention, father's intention, was not to yank the kids and regain custody right away. So that option was preserved in that way. Regardless of that preservation, we argue that it is plain error because it's a legal requirement. It's a legal requirement that the court consider those alternatives. The alternatives are not many, right? It's pretty much custody and guardianship, termination, restore custody, sometimes individualized permanency. It's not a very long list. So the court has to do it. And that, I think, is well supported by not only the case law in BTB and its progeny, but in 80-4-301, that subsection 1 that talks about the termination analysis being subject to the protections of subsection 104 or section 104. And that's the one.
So in your view, what obligation does a party in father's shoes have to suggest alternatives that ought to be considered as part of the strictly necessary best interest analysis?
None. The burden is squarely on the petitioning party. Part of the strictly necessary burden is that they have to show that no other alternatives are feasible. Otherwise, we're essentially turning permanent custody and guardianship into a version of an affirmative defense determination. And that's not how the burden's run. The burden is always and completely squarely on the petitioning party, whether it's the state, whether it's a private party. There is no burden on the parent to come up with the feasible alternatives. It's ideal, maybe. It's easier, maybe, but without evidence from the other side showing that those alternatives are not feasible, they haven't met their burden to show strictly necessary.
Well, if that's true, then there can never be a preservation issue in this context, right?
I wouldn't think so. I mean, we raised the plain error argument as a precaution because we anticipated a preservation response, but I don't think it actually is a problem in these cases. I think that the burden's always with the petitioning party, and so there is no preservation error because the parent hasn't raised every feasible alternative or which feasible terms, particularly where you have they're very limited, and here it was the status quo. So the court needed to consider it as part of the analysis.
And this may be a silly question, but do you think the court just made a legal error in not understanding that a permanent guardianship would not bounce a kid back and forth between, you know, homes? Because it does seem like, I mean, that was clearly a concern for the court.
Mhm.
And maybe was that just a legal error or a misunderstanding of what a permanent guardianship actually is?
It seemed to be. The court did not seem to grasp well the legal implications of a permanent custody and guardianship versus a regular guardianship. So the main distinction being that a parent cannot petition to change it. It cannot be changed based on a substantial change in circumstances. It has to be changed by the guardians. So that would have fully mitigated the court's concern, and that's why that finding does not preclude the feasible alternatives to termination, as argued by Mr. Hancock.
But given that, then doesn't father have some sort of obligation to at least address this issue with the court below?
That would be putting the burden on the parent at that point. If father has to explain why all those alternatives are feasible, then we're placing the burden on the parent who's not the petitioning party. And under the statutes, I don't think that's the appropriate way for that to run. This is partly an issue of terminations being able to happen in both juvenile and district court. Right? Juvenile courts know this. Juvenile courts understand what permanent custody and guardianships are. They've seen and ordered them many times. District courts are less familiar. And when you have a combined adoption termination petition that originates in district court, again, you have this issue where it's not like juvenile court where they've seen the parties through multiple hearings, they've watched this case develop, they know the parties, on as much as you can know them through court. It's a very different animal, and it becomes much more difficult for the district court to grasp the entirety of the circumstances surrounding a family based on a one-day trial. And when they don't have that background information about what those options are, we get these kinds of very thin rulings where there's not enough findings to support a proper strictly necessary analysis. And even if we do place that burden on the parent, even if we do say that it was father's responsibility to bring up permanent custody and guardianship, talk about why that's not a concern the way the court was concerned. I mean, first, that concern comes up for the first time in the court's ruling, right? It's not something that has come up before in the case and that father failed to address later. He would have had to address that with a post-judgment motion, and that doesn't seem like it should be a requirement in every one of these cases for father to address that post-judgment instead of just taking it up on appeal, which is what we're doing now. But we do think that the plain error analysis as a backstop applies squarely here. This is an obvious error, just in the sense, not obvious in the sense that the court didn't understand permanent custody and guardianship, but obvious in the sense that the court didn't even think about any other alternative, just in any form. So the court wasn't required to have.
The court did seem to have given some thought to giving custody back to your client in the moment, especially in the court's oral ruling, which was a little bit more involved than the written ruling.
Mhm.
So the court did seem to consider, well, if I don't terminate, then it looks like the child's going to go back with father. The court didn't, though, consider in either the written or the oral ruling, really, that I can see, consider the possibility of a guardianship. So the court did, I think, consider one alternative. It just didn't consider this other one. Is that a fair characterization of the evidence, or do you take issue with that?
I think that's a fair characterization of the legal problem. Certainly, there's not a legal problem that the court didn't consider returning custody to father. There is a legal problem in the sense that the court didn't consider all of the feasible alternatives to termination. And that's coming again from the strictly necessary prong. Where I think there is also a serious problem with the court's consideration of returning custody to father is there's just not adequate findings to support not returning custody. Almost all of the court's findings are based on events in the fairly distant past. The initial events that led to, again, it's not a removal here. Father voluntarily placed his children with maternal grandparents in order to do exactly what we would want a parent to do in these circumstances, and go into recovery and deal with those issues, and then come back as a parent. And the court didn't really make any findings about father's present ability to parent. All right, there was very little, and the ones that the court did make were positive. He did find that father was stable, father had done an excellent job in recovery, and that overall those were positive attributes.
So what is the relief that you're asking for here? If we think that you have the better of the arguments, you're asking us to do what exactly?
I would ask this court to remand for a completely new best interest analysis, a holistic best interest analysis. Because it has to be present tense, we need to look at all the circumstances as they exist now, not as they existed at the time of trial. And that would require essentially redoing that entire prong again.
So it's essentially a vacate and remand, not a determination that what the district court did was against the weight, but a determination that, hey, the district court's analysis was incomplete, and we need to send it back to have the district court sort of finish this piece that it never really did. Do I understand that correctly?
That's correct, but I want to be very specific in making sure that it's not just saying, asking the district court to remand only for the permanent custody and guardianship piece, but to redo the entire best interest analysis holistically. So having all of the options on the table again is the best way to put that. Thank you.
Thank you, Ms. Marichal. Mr. Hancock?
Good morning. I'll start with the all feasible alternative argument. Father did claim that he preserved this issue. He cited the record at 687 through 688 and 690 through 691. After carefully reviewing the record at these sites, the only alternative determination that was arguably proposed by the father is that he wants therapy and a reunification process, and that reunification begin. The father never proposed the alternative of permanent custody and guardianship to the grandparents that he is arguing before this court. I think father recognized this when he made the plain error argument. However, this alternative determination is precluded by the court's best interest findings and determination.
Well, let's talk about preservation for a second, Mr. Hancock. I mean,
Sure.
can you respond to Ms. Marichal's point that, number one, the burden is on your client to show best interest and that it's strictly necessary to terminate, and number two, sort of subsidiary point, is that the status quo, the current condition when the parties come in front of the court, is a permanent custody and guardianship, and the court has to decide whether to change that or not. And so in that sense, Ms. Marichal's argument is this is effectively preserved. There's no way we can say the court didn't have an opportunity to rule on this, given that the court had to decide whether to upset this current status quo or not. What's your response to that?
Well, I disagree that there's only certain alternatives. I think there could be literally dozens of alternatives. And do we really want to task trial courts with having to investigate and advocate for different alternatives when there could be so many? I mean, there could be all kinds of variations of custody, from supervised visitation to joint legal to sole legal to joint physical. I mean, there's a lot of possibilities the court could consider. But to task the court with investigating those alternatives, I think kind of takes him from the role of being an impartial judge to actually being an investigator and advocating certain alternatives that were not presented.
I take your point that, you know, to the extent we have a wide panoply of options here, there might be some obligation on the part of the parent to point some of them out. But in this case, the option that we're talking about was the option that the children were currently operating under at the time of trial. And your clients only win if the court rejects that option. So in that sense, don't we have a situation where the court necessarily had to decide whether to continue a permanent custody and guardianship?
Yeah, as it goes to that specific alternative, I think the court's analysis does address that issue. I mean, he might not use that specific terminology, but the analysis definitely precludes that as an option. And one of the court's primary concerns was if he created a situation where the children could be back in the father's household. Now, I understand the guardianship prong, but guardianship and custody are two different things. And even though they call it permanent custody, it's still modifiable under a substantial material change in circumstances. And because of that part of that arrangement or that specific alternative, I think that the issues that the courts raised precluded that. I think to some extent it's a red herring issue because it was precluded by the analysis. I think that also goes to the plain error argument because I don't think there's any likelihood that the father would have a more favorable outcome based upon the district court's analysis.
Mr. Hancock, do you would you agree that it seems like the majority of the court's findings about why it's in the best interest of the children, the child, to terminate were based on circumstances that happened when the kids went to live with their grandparents in the first place? That there was no current day sort of evidence or discussion about father's parenting abilities at the time of the trial.
Well, I think the court's factual findings covered both the past and the present. The court certainly considered what happened in the past and how come the children ended up with the grandparents in the first place. But the court also considered the father's current living situation, from his housing to his relationship status to also the children's current situation, the children's current emotional state of mind, how they were doing academically. All of that, I think, was covered with those findings. So I think to say it was focused just on what happened in the past, I don't think that's accurate because the court also considered the present situation, the present condition of the children's, and the father's current circumstances. So I think that would be unfair to the court to say he didn't consider the current situation. I think he did. So really what I wanted to look at was the best interest analysis. And there was a real divergence here in how the parties analyzed the case. The father attempts to analyze the case as though a feasible alternative to termination, specifically permanent custody and guardianship, again, an option never raised by the father at trial. He almost wants to analyze this like a third prong to the two-part test for the termination of parental rights. And feasible alternatives, they speak directly to the strictly necessary factor of the best interest analysis. And this argument is comparable to the guardian ad litem's argument in the interest of BTB. In BTB, the guardian ad litem argued that strictly necessary should be a third prong of the test and not tied to the best interest analysis. And as the BTB court stated, strictly necessary cannot exist in a vacuum. And neither can a specific alternative determination. And the Supreme Court's held that when we interpret this act, it needs to be interpreted as a whole. And the termination must be strictly necessary to promote the child's best interests. And the paramount consideration is always what's going to be best for the child. It comes down to a best interest type analysis. And the court further elaborated on the strictly necessary and best interest analysis in the interest of GD. As it did in BTB, the court continued. Go ahead. I'm sorry. Go ahead.
Can I break in there with a question, Mr. Hancock? We've got a recent case from our Supreme Court just earlier this year, came out in February, called JAL, where the Supreme Court seemed to reject the following syllogism. The children need stability. Adoption provides the greatest level of stability. Therefore, termination is necessary because there can't be an adoption without termination. That basic syllogism seems to have been squarely rejected by the Supreme Court in paragraph 24 of JAL, where they said, look, you can't just look at the categorical nature of an adoption. Adoptions are always more stable than guardianships or other options. You've got to look at sort of case-specific reasons as to why termination is strictly necessary to serve the best interest of the children in this case. And I think Ms. Marischal's part of her argument is that's exactly the syllogism the district court sort of fell into here, which is, hey, it looks like these children need stability. I don't want them ping-ponging back and forth. Adoption is the best way to get stability, and I can't terminate. I can't do an adoption without terminate, so therefore termination is strictly necessary. That seems to be the core of the district court's best interest analysis on page 423 of the record. So I guess I want your thoughts on whether you think the district court fell into the error that the Supreme Court identified in JAL, and if so, what we do about it, or if not, why not?
Well, I don't think the trial court made its determination based upon any type of a categorical concern. I think permanency and stability was certainly part of the factors the court considered, but he also tied those factors into specific findings, specifically the impact on the children, that this had happened more than one time. They'd been with the home, with the grandparents, back in the home with the parents, back with the parents. So there was a history there that the court went through in some detailed factual findings that I think really cuts against the position that this would just be based upon some type of categorical type concern. And you know, the district court did make some detailed factual findings. I don't think we can really criticize the court for not considering or making detailed findings. He did, and those findings really relate directly to the statutory factors, but also case law factors. But I think that's a good point. I'm familiar with the case, but I don't think this was a categorical type issue. And you know, the other understanding is when we're looking at best interests, when there's two placement options that would equally benefit a child, that's really where the strictly necessary requirement begins to operate. In this situation, I didn't see that the permanent guardianship and permanent custody and guardianship would be comparable to adoption. There are differences there that I think we need to recognize.
Well, that may be true, Mr. Hancock, but the district court didn't really seem to grapple with that question. I think that's the main issue Ms. Marischal is raising here, is that the district court didn't really endeavor to explain why a permanent custody and guardianship situation wouldn't be at least equally in favor of the children's best interest in this situation. And the district court is, in her view, obligated to at least explain that in a convincing way. What's your response to that?
My understanding of the district court's position on that issue was that permanent custody and guardianship would create a situation where potentially reunification would have to occur. And it would create a situation where potentially the children would be back in the home with the father. So I think the court did make some findings along those lines, and that was his resolution. The court's biggest concern was what would happen to these children if they ever had to go back into the parents' household. And I think he did address that. The court may not have put a lot of time into that part of it or a lot of analysis, but I think it was addressed. I don't know if that adequately addressed the issue for the court, or are there any other issues the court would like me to address?
It doesn't appear so.
Okay,
Thank you, Mr. Hancock.
thank you.
I'll start with the error that Judge Harris was raising from JL, the categorical concerns error, and I think that's absolutely present here. The finding, I think, the conclusion finding in the court's decision that best encapsulates this is the one that says, if the court does not terminate parental rights, the adoption cannot occur. And that's a classic categorical finding, right? Like it's telegraphing what the court's thinking here, that adoption's more stable, adoption's more safe. Let's go with adoption. I can't do that unless I terminate, so termination strictly necessary. That's that exact syllogism. So absolutely, that's what the court's analysis reflects here. The other point about reunification, the court did talk about that in the oral ruling, did not talk about that so much in the written ruling, but to the extent that that comes into play, reunification has to happen either way, reunification therapy. So it doesn't preclude anything. It doesn't inform as to whether that's returning custody or a guardianship, because that would have to happen no matter what. And father acknowledged that reality.
What do you mean that would have to happen either way? It wouldn't have to happen if termination occurs, right?
No, I mean, yeah, I mean, if either custody or permanent custody and guardianship, with those two options, reunification therapy has to occur. So it doesn't preclude one or the other, that was something that would have to occur. So to the extent that it just doesn't play into the distinction between those two options. Obviously, termination, yes, that's a different issue, but with whether or not that precludes custody or permanent custody and guardianship, reunification is something that would have to occur in either case. So that one doesn't really play into informing whether the court considered the distinction between the alternatives to termination, I guess is the clearest way to put that. In terms of the findings that support termination and support what Mr. Hancock is arguing, support only termination. The findings that father was stable, which is on record 422, that's finding number 80, that pretty much carries the day there. I mean, there aren't any other findings about father's ability to parent, father's connection with the child. The court sort of, again, categorically decides that the parental bond is non-existent, but there isn't really any evidence to say that other than the self-serving testimony of the maternal grandparents. So there's very little evidence to support anything with respect to what their relationship is like, what kind of parenting the father can do, what kind of stability he can provide, and most importantly, whether or not that risk of bouncing back and forth is really a risk at present day. I mean, father went through a year and a half of intensive treatment, both through incarceration, through outpatient therapy, through inpatient therapy. It's a huge amount of work and rehabilitation. And the court acknowledged that. The court fully gave father credit for that, but then still found that the situation was unstable, and that just doesn't follow.
Yeah, what do you make of the sort of disconnect between the written finding number 80 and some of the court's comments in the oral ruling with regard to stability? In the oral ruling, the court said that the father's stability is still questionable. It's too new to know if the homes are even stable. He's not even paying rent in the home he lives in right now. He has no rights to the home. He's not married to that person. I don't know how stable that relationship is. There's no stability there. And then we see finding 80 where the court says Jesse's situation is stable, and because of the living situation, it's not required to pay rent. What do you make of that?
First, just from the legal perspective, the written ruling controls. So if to the extent a written finding conflicts with an oral ruling, it's the written finding that carries the day. And here the written finding is that he is stable. The other problem, sort of digging more into the facts of this case, is that, again, father wasn't able to present any witnesses about his current stability because of this Rule 26 objection, something that frankly probably wouldn't happen in juvenile court because of the relaxed rules of evidence there and rules of procedure. So father wasn't really able to give that evidence, and the court never really heard any evidence on that stability. Again, it was all sort of from the testimony of from the perspective of the maternal grandparents. So there wasn't a lot to support those oral findings, such as they are, and they were completely contradicted by the written finding, which is the legally binding finding. So in closing, we would ask this court to reverse for a new best interest analysis, again, with all of the options on the table so that we can fully flesh out what is best for this child. Thank you.
Thank you, Ms. Marichal. Mr. Hancock, I invite you to rejoin us. Thank you, counsel, both for your arguments today and your briefing in this matter. Very helpful. We will take this matter under advisement and render a written decision as soon as we can. With that, we will be in recess until 11 o'clock.
Thank you.
Thank you.